the various domain of cyber forensics, particularly the drone forensics. And the speaker, you are already aware that was the best possible resource person for that subject. Now, as you know that the crime and its various nuances are very important part for our understanding, not only for our syllabus of almost all the courses we are running in our institute, but as a common man also. Understanding about crime is very, very important. The reason is as simple, because any one of us may become prey to crime, or sometime knowingly or unknowingly we may be an accused. So both from the angle of victim side as well as from the accused side, it is very pertinent to understand what is crime. Sometime we get some other word also, particularly if you see our Indian Penal Code of 1860, then there you will find word offense. You do not get the word crime. So technically speaking, is there any difference between crime and offense? This is the question will come to mind. So the answer is yes, there is difference between crime and offense. In fact, crime is a wider term. It is a genus and offense is an species. The major difference, you can say, that crime involves ethical part also. Sometimes those violations which are ethical are also covered under crime. But offense are those acts which are being penalized. Which are being penalized, say for example in our country under penal code, Indian Penal Code or other statute. So we will discuss all those points. Here today I am going to talk about how law has been evolved over the period of time since our past history of civilization, how this codified law has evolved. So briefly I will tell you few things I have already discussed with you, but I just thought appropriate to take this call so that we can understand this very basic nuance of law, that what is crime. Okay. Then I will also touch upon little bit about evidence part, and then of course very important part I will touch, what is an FIR, the first information report, which section it is dealt with, and what are the implications suppose you want to lodge an FIR of a crime or any complaint. Who can lodge that FIR? We'll discuss that. Is the only victim or the only family member, friend, or can any other person also write? That we will answer this question. Suppose you go to police station and for one reason or other the police station do not give any attention to lodge the FIR. So what are the remedies? So those remedy also we will discuss today. And then what is investigation? How the investigation should be carried out? What is the importance of evidence, and how evidence, particularly forensic evidence, because we are the Institute of Forensic Science. So what is the importance of forensic evidence, the quality, the circumstantial evidence, and many more things we will discuss, not only for your syllabus point of view, but of course we will be discussing particularly for a common man also, so that it should be understood like a layman language. So I will not go for very jargonized word. So as I told you that what is the need of law, why we were developing law, and how this law has been evolved. So if you see the primitive society, पानी है क्या? So if we see the primitive society, the question comes to our mind whether they were all lawless or there was any mechanism for social control. Because you know, law is basically a mechanism for social control. Basically, based on law, the society is being disciplined. Otherwise, they will be completely lawlessness. So, we generally believe, or we may tend to think, whether primitive society in very old ages, whether there were completely lawlessness. The answer is no. There were certain mechanism. And the most important mechanism was the evolving religion. Religion is also basically a social method for controlling the conduct of the individual as well as the society. So the role of religion is basically social control. Okay. Then there are a lot of traditions, customs, and many more things. So it is not only the law. Law is a very, very evolved thing. We will talk how the law was built and what was the codified law and how it got into existence. So the first of all, the question comes, why even the religion was required? What was the need of social control primarily? The reason was very simple, because the dominating society or the dominating groups, because there was no society, if you see the very primitive society, so they were having in a very small number of groups. People, they were living in clusters. They were dominating, and the dominating group were ransacking the weaker section. And suppose after some time, due to natural calamity, or say maybe 15 years later or 20, 50 years, that dominant group may become weaker and other will also ransack them. So there was a chaotic system in the society. So what are you seeing on this social contract theory? Basically define that how a state was created. What was the need to create a state? So the need of creating a state was to bring a mechanism of social control. What our state is doing, suppose we are India is a state, US is a state, and many more such jurisdictions, they are the states. What is their primary job? Primary job is for social control. Right? So social control is the basic purpose of creating the state. There are various thinkers for defining social contract theory. Why we call it social contract theory? Because it is believed that there was a contract between the people of the locality and who were the ruler or who were to govern. Right, there was a contract, although there was no such contract in actual, but to understand it theoretically, this is considered social contract theory, that there was a contract between the common people and the rulers or the governing body to say that you please protect my body and my property. So this state was created for the purpose of protection of property as well as person. And believe me that till date, the role of state is same. The development, other things comes very late. And still, if you hypothetically think that a village or any city is being created with all the developing facilities, but until unless you ensure that land order and crime control, or you can say the protection of body and property is ensured, nobody would like to stay. So still the basic purpose for which the state was created, for the purpose of protection of property and person, remains the same for the function of the state. Right? So this is the reason. Now if we just go little ahead, you may also get two terms, ethics and law. Right? These are very basic two terms. Ethics are basically, they are not very much codified many times. Ethics are varies from place to place. But And ethics are derivative of various religions also. So in a society, few ethical values are common in different religion, few may be different in different religions. So like law, ethics are also variable with the society. Okay. And I mentioned in many times that we should never consider any society with our own standard. That is called ethnocentrism. We should look any practice of that society from their angle. For example, suppose a country or any place on geographical map, if it is covered with snow, right, there may be very little opportunity to grow vegetables. So the society over there will definitely be non-vegetarian. So considering that whether vegetarian is good or non-vegetarian is good is not a very healthy trend to evaluate any society or any group of people or individual persons. Likewise, if you see the entire culture, so culture develops with the geographical and socio-economic and various other factors. So it is the requirement of that particular geography, the scenario, the environment and many more things, how the culture are different from one place to another. As far as the society is concerned, if we see that up to 13th, 14th, 15th century, most of the time the kings or the rulers, they were being dominated by some religious head, right? Okay, so those society where all the religion, all the people follow the same religion, those are called monolithic society. Society were called monolithic. If they are following the same kind of religion, there will be no problem. But suppose there are multi-religious society, people of different religion are living together, then if the king or the lawmaker or the ruler is linked with a particular religious head, normally if you see in the earlier pictures or movies sometime, that the king is sitting at the center and some religious head will also be accompanying him aside, right? So in those scenario, people will think that if a king is dominated or being advised by a particular person of a particular religion, then probably my interest may not be served equally. So that kind of difference will be there. So this you know very well that in a governance or the government has three wings, you are aware. What are those three wings? One is lawmaking, that is called legislature. Another is resolving the disputes, that is judiciary. And the third one is the execution, the executive body, right? So lawmaking is the major role of the king or the governing body. So as I mentioned, that if a religious head is influencing the decision of the kingmaker, then law will always be affected. Meaning thereby, law should not get affected by external factors. This is the basic purpose how law should be made. Law should be exactly the creation by the ruling body without any influence. This is the requirement. So John Austin in 17th century, he was basically a ex-army man, highly disciplined guy. If you see his photo on Google, you will find him a very, disciplined person having mustaches and a very different, elegant face with highly decorated attire and all. Apart from being a army personnel, he was a very big and very erudite jurist also, the legal expert. So he first time defined law. And he gave very simple definition, although it is little bigger, but I will shorten it for your purpose just to understand. He said, what is law? Law is basically command of sovereign. Law is command of sovereign. Sovereign means the identity which take independent decision without any influence. That means the state or the ruler, they are independent in decision making. Okay. So there are two words, command of sovereign. Command means the order, the dictates. So law is what? Law is command given by the sovereign body. Okay. By this definition, Austin actually divorced all external factors. Now lawmaking become completely the domain of the governing body. And this definition worked very well. This definition was accepted across globe almost. Okay. Till Holocaust. You are well aware, I think earlier also some time back, I just gave some reference of this point which I am talking. Just for the purpose of recapitulating what we have discussed earlier, I thought appropriate to repeat few points, but we'll pick up fast the next topics. So Holocaust was carried out by Hitler in Germany in 1930s in more aggressive manner, whereby Nazis, the dominant, group, very, inhuman manner, they have massacred thousands of Jews in nearly, say, about 10 years or so, a decade time or so. Okay. So this is one of the biggest inhuman conduct by the state. It was state sponsored, ethnic cleansing. The term they said, ethnic cleansing. In the name of cleaning the society, they said that the Jews are not complete human being. They are maligning our race. So it was a racial loaded approach just to clean, ethnic cleansing. Okay. There are some genetic things also to talk about, but I don't want to bring it more cumbersome. But anyway. So it is said that nearly 20 million people, 20 million Jews were killed during those periods, right? So when this Holocaust was in progress, the Second World War started in 1939. Very good. And it continued for about 4 or 5 years. And then that ultimately Hitler committed suicide because their, allied forces, the Germany was defeated by allied forces. And when he committed suicide, his second men, the people who were actually second liner to execute the order what Hitler gave, they were being caught. And a trial was conducted in the city named Nuremberg. And it is called Nuremberg trial. Nuremberg is the name of a city in Germany. So, as you know, when any trial be conducted for a criminal charge, the allegations are being read out, asking that these are the allegations, whether you accept these allegations or you want trial. So when it was explained before the accused person that look, you have killed so many people, Nazis, why you should not be tried? Why the punishment should not be awarded to you? So they gave a reply. And that is very, very important for us to understand. So they said that look, we did nothing wrong. We committed no crime. Why? Because we simply obey the command of sovereign. So what was dictated by Hitler to us, we were just executing body and we have simply followed the command. And command of sovereign is called law. So how can we call it illegal? So that was the prime question before the court. Although it is a fact that they were being tried, the punishment was awarded to them, but cutting a story short, the answer given by them put a question mark on the definition given by Austin. And here from law was divided into two parts, the good law and bad law. That means all command of sovereign cannot be a good law. And I generally give example, very simple example, that say for example, if any government which is capable of making law take a decision that sun rises in east, it is a very old fashion, we want to change it, and they take a final call that sun rises in west, and the proposal or bill passed in one house, in another house get assented by the highest authority, say in India by the president, and then law got made, right? So whether this law is valid or good or bad, right? So who will decide this? It will be decided by the court in case it goes to court, and this is called judicial review. This is called judicial review. If I connect judicial review with your constitution, so the footprint of judicial review in our Indian Constitution of 1950, you can see in Article 13. Article 13 has the impression that judiciary has very important role for judicial review. And what type of judicial review we have? It is basically two type of judicial review. It is globally you can find. One is called due process of law and another is called procedure established by law. Due process of law and procedure established by law. Now what is the difference between two? This is again a question comes to mind. Very simple to understand. But before understanding this difference, let us understand that law can be classified in various manner on various parameters, but here we can divide it on two parameters. One is called the substance and another is called procedures. So law are of two types, either substantive or procedural. Sometimes there may be hybrid also. Now let me just explain for your simplicity. Substance means that law which tell about, say for example, crime, that what are the ingredients of a particular crime, say murder, theft, injury, sexual offense, rape, or maybe outraging modesty. Okay, so those kind of ingredient, that particular law which explain is called substantive law. Like IPC is very good example for it in our country. On the other hand, procedure explain the procedural part for collection of evidence, for trial in the court, and many more such type of procedures involved therein. And example may be Evidence Act in India or any country, or procedural code, maybe civil procedure code or maybe criminal procedure code. So now let us come back. Due process of review actually review both substance as well as procedure. And due process is observed in many countries including US. Due process of law. Due process of law, as I mentioned, is a more power for judiciary to review the entire ambit of law. But on the other hand, procedure established by law is limited. looking only the procedure established in the statute for a particular law, how to implement. Now this time, when this Nuremberg trial concluded in 1946, almost at that time, we were also in the process of making our Indian Constitution. And we also struggle what type of judicial review we should adopt. And ultimately, this task was given to the then very, well-known jurist called Rao. He went to US and many more countries to study both type of judicial review. In US, he met the then Justice Frankfurter of Supreme Court. He was again a very great jurist of his time. Frankfurter suggested him that, look, for a common man, it is well understood that due process of law is better than procedure established by law. But India is a melting pot of, social differentiation. Various type of caste, different language, regions, and many more such type of variance in the society, Indian society at large. Second point, he mentioned that in your country, India, the resources are unequally distributed. Right? And when you make the government, then of course you will try to equal distribution for resources like land and many other things. Okay? Because those time people were jamidars and most of the, chunk of land were in the name of very handful people. Okay? So that equal distribution of resource was very much important, and that Jamidari Abolition Act and many things followed when we got independence and all, right? Ultimately, cutting story short, we adopted procedure established by law in our Constitution, which can be seen in Article 21. Few articles you must always remember. One point is called Golden Triangle in our Indian Constitution. There are three very important articles, my dear friends. At the top of the triangle, Article 21. That is right to life. Remember these three articles always. At the top, Article 21, right to life. Right to life has multi-dimension. Life is not like an animal life. Life with dignity. Right? Then right to privacy. And many more expansion of the right to education also followed some time later. Of course, we have right to education, but only up to class 5th, not for higher education at all. So we are evolving in those types. So Article 21 get lot of expansion over the period of time. Then another important part of Golden Triangle is right to equality. And on the third corner of the triangle is right to speech or right to freedom of speech and expression. That's very, very important. Okay. So these three articles are most important. I will give you a very simple example how right to equality is equally is very, very natural, and these rights are called inalienated rights. You cannot divest. They are called natural rights. Why they are natural? Because they have been provided by the nature. They have not created by any statute per se. And I gave example earlier also, if you remember, that suppose if you go to your home back and there are two kids of 3-4 year old, those do not know what is Constitution, what is Article 21, 25, whatever. Okay. And you just give them toffee in their hand and ask them to close the fist and give to another child also. The first child will first see how many toffee have you given to the another one? He or she does not know about we have Indian Constitution, right to life, Article 14 and blah blah blah. Right? Equally, suppose if you have done something similar, and I give example of a government servant. Suppose if my promotion, example I am just citing, suppose was due on 1st of January this year. Okay. And for one reason or other, it was not being done for the entire batch. Okay. I will list further. I will say what nonsense, no problem. It will be done whenever the time come and all. But suppose if my batchmate get that promotion on that day, and if I do not get, then person will cry. Right? So it is not actually the requirement. It is basically comparison. So right to equality is a comparative affair. Likewise, say liberty. I always give example, a very simple example. Say you have some bird and kept it in a cage with all good facility, with AC room, with very good to eat, drink and what not. Okay. But the moment you open the cage, even outside it is very hot, having nothing to eat or drink, but the bird fly. You will say the bird is bird, has no mind and brain, but it will say, I don't like all what you have. I want my freedom. And the simple thing you can see in life also, that many times you must have read in the newspaper that in a particular protection home, Balgrah, the children has run away. They are not going to get very good life outside. The life may be even miserable. They may not get 2 square meal even. But they do not want to be captivity. They want freedom. Right? So that freedom is very, that is why these rights are called natural rights. These are called inalienable rights. They cannot be divested. Okay. So with this background, now let me tell you, I think just how to understand the nuances of law. If somebody asks you that what is law, everybody cannot be the jurist, cannot be the student or the perfect, having knowledge of law. But law is required for everybody because law demands that ignorance of law is not any excuse. Ignorantia juris non excusat. Ignorance of law is not an excuse. Why this phrase? Why this Latin maxim? Suppose if this Latin maxim is not there, then somebody will commit crime and can take plea that I was unaware of law. Right, then there will be chaotic situation. So law presume, although it is a very over-ambitious presumption, but this is a fact, that whether you are literate, illiterate, whether you have read law or not, whatever cumbersome law may be, you are presumed to know the law of the land. Okay. So now the question arises that I am not a legal expert. Law expect me to know what is law. So what is law? Okay. So if you just remember these 3 words, just, reasonable and fair, JRF. Many of you in your studies sometime later will realize many of you may be having this idea already. JRF, Junior Research Fellowship. So I have borrowed this terminology from that JRF to just, reasonable and fair. So let us understand what JRF stands for to understand law. Just means justice. Any act, whatever you are doing, if it emanates justice, then it will be legal. You need not to follow any book or statute. And if anything what you do result into injustice, will anywhere will be illegal. So justice is the hallmark of law. Or in other words, you can say that justice is aimed to deliver, law is aimed to deliver justice. Is clear? Then second is the reasonability. Reason means the logic. You can say the sense. Okay, logic, reasonability. Okay. I many times mention this, that sometimes we say that this person is very well oriented, he talks sense, he articulate well. What he does the reasonable talk. So I always tell you guys that if you want to be a sensible person, whatever you talk, it should be reasonable. Reasonability is the essence of life. You have to adopt it, you have to learn it, you have to imbibe it. Reasonableness in your action, in your thought process, in your deliberation is very much important to bring you in future, what kind of person you are going to be. So reasonability is a very, very important part, not only for law. As I mentioned that reasonableness, when I was giving example of creating law, turning that sun rises in the west, that was not reasonable. That reasonability test is very, very important for judicial review. Then fair. Fairness means transparency, no bias, no favoritism, no nepotism, completely transparent. आईने की तरह साफ होना, like anybody can come and see. So RTI, for example, is a very important tool to bring fairness in decision making, isn't it? You have to display everything. Suppose you are recruiting for some post, maybe teachers or some other post. Even if whatever good way, you have no bad intention, there is no corruption, but still people will feel, if you have not advertised those posts, that probably some hanky-panky has been done. There is no transparency, right? So whenever you take decision, you should always think that it should be transparent. It should not be bias. There should not be any kind of favoritism. Then only your decision will be good. One point here I want to mention before I move ahead is natural justice. What is natural justice? The question comes first, what is natural in natural justice? This is very, very important part to understand. Natural justice. Natural means that justice is not subservient to anybody. Nature has its own way of doing justice. And we all accept this fact very truly, that whenever we are in very thick situation, in very hot water, then we always say, oh, if he is not giving me justice, God will give me, nature will give me. Bhagwan to hai na, upar wala dekhega. What is that? That is basically natural justice. Now I just expand it a little bit more. As I mentioned that everything was decided by nature earlier, when we were not having the modern concept of codified law as we have today. Slowly and gradually, so the entire, if you see the set theory, in the entire ring, there was no codified law. Everything was decided by nature. Then slowly and gradually, we start making law. So in that bigger ring, you created smaller rings, the subsets. Say for example, IPC, CRPC, then POCSO Act, then different other acts in different country. So where we should use natural justice principles. We should use natural justice principle where there is no specific law, there is no codified law, or those area where either law is not available, there is completely void, or if there is any ambiguity to explain or to interpret the law. So natural justice are used especially for two purposes. One, if there is no law, there is a void. Okay. Number two, if there is law, but the law have some ambiguity or some conundrum. So it brings clarity actually. Now, what are the yardstick to use natural justice? What are the parameters? So there are many parameters, but I will mention here only three which are the most vital and important. The first one is Odi alteram partem. Odi alteram partem. If you remember, good. If you do not remember, even more good. Doesn't matter. You have to just understand what the meaning is. Odi means hearing, audio. Alteram means alternative. Partem means party. Odi alteram partem. Here alternative party. What do you mean to say this? It means that whenever there is a complaint, first listen another party also before taking decision. Do not jump to conclusion before giving opportunity to the alleged person. That is the reason why we have the trial system. You remember, maybe you may be very young or may not be, most of you must not have been born by then. When Mrs. Indira Gandhi was assassinated in the broad daylight, around mid of the day, everybody was knowing that who has committed this crime. They were being caught red-handed on spot. But still it took multiple years to conclude the trial. Then appeal in the Supreme Court. So what is that? That you have to give full opportunity to the opposite party so that they can explain situations. And then only you should take, otherwise there must be a banana state type of justice, that you know he or she has done it, then kill him or give whatever punishment you want to give. So that cannot be justified. So this is Odi alteram partem. And it is not only court, in our own day-to-day life also. Suppose somebody complains you are in authority or you are at home. You must ask the other person also when you take a decision. So it's a common man requirement. Then another is that you cannot be judged in your own causa. It means that when you have interest in the subject matter, you should not be judged. Suppose you have interest. I give you example to understand. Suppose there is one interview as conducting for, say, recruitment of teachers. And suppose I, as the director, I am the chairman of the board, and my own family member is also appearing for that interview. So natural justice principle demands that I should not be part of that interview. Whatever good decision you take, whatever neutral decision you take, it will always be violation of natural justice. And who will disclose this fact? It will be disclosed by the person concerned. Many of common men may not be knowing that this gentleman is known to me. So it is your responsibility when you are taking decision to disclose such type of facts. Okay. The third one is that the person who have heard the case must finally decide. I will give the example, then you can understand better. Suppose there is a case going on in a court, the judge is sitting there and procedure is going on. And one fine day, that judge got transfer and now the entire proceeding is almost complete except writing the judgment, and the new judge take over the office. Normally speaking, one will say that, oh, everything is done, now only writing part is left, so let him complete. The natural justice says no. He should be present actually when the entire proceeding was going on. Why? Because it is not the only sad part. It is unsaid part also, your body language. When you are deposing before the court, you must have seen many things which not being recorded for making decision. So natural justice demand that until and unless you have heard the case properly, you cannot take a final decision. Okay. So these are few areas which you must be aware of, how decisions should be taken and how the law must be understood. Now, I have already mentioned you that civil law and criminal law is one classification, then substantive law or procedural law is another classification. So law can be divided on various manners and methods. This is again a very important thing to understand, the difference between civil matter and criminal matter. I will share these slides with you, no problem. I will circulate to you. You give them to understand. But note down the points which I am telling, not necessarily everything I am able to write on the slides. And on slides, always remember, because you will also be presenting, always follow the rule of presentation on, PPT and all, 6:6. What is 6:6 rule in presentation? That on a slide, there should be maximum 6 lines, and each line should have not more than 6 words. That is the ideal situation. Write less, explain more. Otherwise, what happens? The audience will start reading the lines. They will hardly listen the speaker. So only give some glimpse and then explain. And make this habit in your presentation, and I request the teachers also that give them kind of work or presentation. At least once in a week, there should be some presentation in the classroom. Let them come prepared. At least once in a week, let them teach in the class, give the subject, and then you can intervene that this can be a differentiation. Suppose you are teaching natural justice. Let them come and talk, and then you can intervene, so that the students should get confidence in standing on dais, speaking ability, and expression will come in a better manner. Let's understand. Any act or omission means what you are supposed to do, you are abstaining doing it. That is called omission. And this is very important to understand. This slide will go through entire your life. Understand this slide very properly. Any act or omission which is prohibited by law is a wrong thing to do. Up to this level, both crime and civil matters are similar. No difference. If that wrong is punished or fined or both, then it is a crime. Or that wrong, if you are permitted for compensation the opposite party or compromise between the party, then it is civil matter. So if you want to define criminal matter, any act or omission which is prohibited by law and awarded punishment or fine is a crime. Is a crime. I again repeat, any act or omission which is prohibited by law and awarded by punishment or fine or both is a crime. On the other hand, any act or omission prohibited by law under which compensation or compromise or both are permitted, then it is a civil matter. Is it clear? Nowadays, there are situations where even in criminal matter, compensation are also been given. Now you will see there are two types of compensation. Compensation by the party and by the state. So normally compensation in the criminal side in general is being given by the state. But nowadays in restorative justice, this is another term to understand. What is restorative justice? And this is a very, very, important term to understand. Restorative justice, restore means restoring the faith of both the parties, so that the harmony between the parties should be restored. Normally what we do in our trials, we generally go for punitive action. We give punishment in criminal matters. Okay? And restorative justice believe that there should be harmony between the parties. So they generally consider that suppose if a person who has committed crime, he accept it and feel sorry for that and compensate himself to the victim, then it will bring more harmony in the society. The ultimate purpose of law is to bring peace and tranquility, harmony in the society, so that we should have the tendency to live in coexistence. Living with coexistence is the ultimate objective of law. I hope it is clear, or any clarification is required, or any question so far. Now this triology is again very important. As I already mentioned, that justice is the hallmark of life. Whatever a person may lose everything in the life, ultimately he or she may ask many a times. As a police officer, I have seen in many cases that in very, very grave situation, in a very diabolic situation, person says, "Sahab, mujhe न्याय दिला दो." So if somebody asks me that what is one attribute of the society which is most demanding, most aspiring for, in my belief, it is justice. And if we do not have this kind of attitude and aptitude to better understand the justice system and justice per se, I think we are not complete human being. The reason being, if we do not understand justice, then either we will fall victim of injustice or we will commit injustice to somebody. Either way, it is the loss of the individual as well as the society. So understanding well the concept of justice is very, very essential part. How to reach justice? You have to find truth behind that fact. Without truth, you cannot reach to justice. So just truth is the process. And then means theory probably you must be knowing. So justice is the end and truth is the procedure. But if you closely watch these two words, both are abstract. They are difficult to determine. अमूर्त रूप हैं ये दोनों. इनको बहुत ज्यादा अमली जामा नहीं पहना सकते सीधे सीधे. तो हाउ टू रीच टू ट्रूथ? थ्रू एविडेंस. So evidence are the ultimate tool to reach to truth and then to arrive at justice. So the role of evidence is very, very important, not only in criminal or civil matter or in the court proceedings, but in our common life also. And what I was talking about reasoning is nothing but evidence based talk. When you talk sense, what are you talking about? You are giving some evidence. Argumentation is reasoning. And how you develop argument? Based on some evidence. So this is the triology you have to understand well if you are dealing with decision making process. I think I have already talked about crime versus offense. Crime and offense, there are subtle difference. Crime is a genus and offense is a species. Offense means offended. Somebody must feel offended with this. Crime used in common language, while offense is a legal term. Section 40 define offense. And how it define? An act or omission prohibited by law and violation prescribe punishment or fine or both. I have already told you in the previous slide. Act or omission prohibited by law, awarded with punishment or fine or both. As simple as that. Otherwise, defining this crime or offense is slightly difficult preposition. Now, what is FIR? So, here from we start with CRPC. The section 154. Please remember few sections without any fail. And 154 of CRPC for your purpose is very, very important to understand. Isn't it? And I request you all to have your one copy by its own, although we will provide in our library, no doubt, but you must have your own copy of Major Act, Criminal Major Act, and you may take bilingual also. It will not cost you more than 200 rupees. Very good quality, you will get 200 rupees and use it permanently with you. Whenever, suppose if there is 154, always open it. Even if you have read 10 times, even 11th times when you read, you always look into it, so that you will understand more and more and more. That is how the law is being understood. Never hesitate thinking that I have already read. You will surprise that whenever you read, you will find some new dimension. And that is the reason why even the senior most judges, the very experienced lawyers, they always carry law books. They are always looking into those treatises. Why? To find more and more new dimension of explanation, interpretation, understanding, and so on and so forth. So always refer the books, refer the particular statute of the law. Now let me explain. Suppose there is a crime. Okay. So as the name suggests, first information has to be given to authority. And for dealing crime, the first authority is police station. What is the first authority? The concerned police station. It has its jurisdiction. And you will surprise to know that all kind of crime, whatever happens in that particular area, will be a subject matter of that particular thana if it is a crime. Crime only and only can be registered at police station, nowhere else. You will surprise even that, say for example, CBI or ED or whatever. CBI cannot take a case until unless it is being forwarded and allotted by the central government, right? Likewise the ED and all. But the police station can lodge an FIR even against anybody. Police station has not to ask any permission by anybody. Of course, there may be some, requirement in a specific law, but in general, police station has very wide, jurisdictional powers than any other agency as far as registration of crime is concerned. So, if you go to police station for registration of a case, then it falls under 154(1). Now the question comes, who can register the case, or who can go for FIR, lodging the FIR, registration of case? Number 1, the victim. 2, any relative, any friend, anybody. Nearby person who has seen it or who claims to have known for it, any passerby or anybody. At last, if nobody is coming forward, then even police can register a case. So there is no hard and fast rule that FIR can be lodged only by victim or by X or Y or Z. Anyone can lodge the FIR who got that information. That is point one. Another is how it can be registered. It can be simply written on a paper, even on digital platform, and it can be forwarded also. It can be handed over in writing or maybe in digital format can be forwarded. So there is no hard and fast rule. Not only by written, you can even tell the police station orally, and then they will note it down, get your signature and register. So there is no hard and fast rule that only in this format or in this model it can be registered or it can be submitted. Okay. So 154, you go to police station, it get registered, then it is part of 154.1. Then 154.2, a copy of that FIR mandatorily to be given to the complainant free of cost. It is the right of the complainant to get a copy. Many a times it doesn't happen for one reason or other. But this is not mercy of anybody. It is very well mentioned in the law book, statute. Nowadays, there are cases of 2017 onwards where Supreme Court has ordered to publish every FIR within 24 hours online, barring few exceptions. Among those exceptions are crime with children, where you have some kind of secrecy, where you have to do some following action. Suppose CBI has registered a case and there is a possibility to conduct a raid, and if you have published it in 24 hours, then every secrecy will be leaked, and then the searches and other things will have no meaning. So there are certain exceptions, but otherwise, as per Supreme Court judgment, since 2017, every FIR has to be online within 24 hours. Okay, this is number 2. Then comes 3. If suppose police station refuse to lodge FIR, then you can go and meet SP and submit the complaint in person, or you can send by post or by email. This comes under 154.3. So 154.1, directly lodging FIR by police station. 2, the complainant has right to get a copy free of cost of the FIR. Right. 3rd, in case police station is refusing or not doing it, then you can go to SP either by in person or by postal or by mail. By any means you can reach out to him, not necessarily in person. If this also doesn't work, in case, then the 3rd remedy is 156.3. It is not 154, remember. It is 156. 156 means through the concerned magistrate, judicial magistrate. You go to police station, but you have to prove the fact that yes, I have gone to police station, I have exhausted both 2 options for me. 154.1 not worked, 154.3 doesn't work, then only I am compelled to come to 156.3. So these are 3 methods how FIR can be registered. I think, am I clear to you, or any query, any question, any observation? Anybody may ask. Yeah, please. Zero FIR, very good question. Many a times, as I mentioned earlier, that every police station has its jurisdictional limits. Suppose a case is being reported which does not fall into that particular jurisdiction. then the court says that in certain circumstances, in the benefit of the victim, the case may be registered in that particular police station where the victim want to get it registered, because that case does not belongs to that jurisdiction. That is why 0 number is being given, and it will be forwarded to the concerned SP to reach to that particular police station. Got this point? But this should not be a common practice. Example I give you, and this is one another issue it may comes to your mind, that suppose it is a running train and you came to know that I slept around 10 o'clock in the night, but when I got up in Ghaziabad or XYZ place, my bag was stolen. I don't know whether it was in Muradabad or Bareilly or which place. So at the last destination where you get down, it is not the last destination of train, it is the last destination where you get down. There you can get it registered. It will be registered on number, but suppose the police station find with some evidence that it was stolen at this station, then they can forward it to the particular railway station. Okay, so this is how the 0 FIR business works. Is it clear? But this you should be well aware, because it is important to understand how the FIR got registered. Now this is a very important question. Initially, as per our original framework of CRPC, FIR was considered to be registered without any hanky-panky, or you can say FIR registration was almost a mandatory feature in our procedural law in CRPC. This question came up because there were certain circumstances where you find that it looks as if the allegations are not prima facie correct. So if it is mandatory, then you have to register the case, and registration of case itself has lot of consequences. I will talk about when we will come that whether all cases should be registered or not registered. We will talk about that. Okay, so this is a very, very important judgment. Lalita Kumari versus State of Uttar Pradesh is our own state case of 2012. Here it was a case of habeas corpus. You know 5 writs. Next time I will talk about 5 writs, particularly under Article 32 of our Constitution, where you can directly go for violation of fundamental rights to Supreme Court. And equally, one can approach the concerned High Court of the state under Article. Very good. Like he gave the answer, you should all know these 2 writs well. Please, I am giving you this home task to you. Have your constitutional book. If you do not have, you can download all these 3 things under your, rather 4. One is IPC, free of cost download is available. IPC, CRPC, Evidence Act and Constitution. These 4 PDF file you should have always on your desktop. And another point I want to make, you all have mobile phone. When your mobile phone is having some problem, you never say I have some fund issues and all. Everybody manage fund for mobile phone. It is only the necessity you feel. So my observation is that equally important is the laptop. You can go for EMI and all, but have your own laptop. These days you get laptop in reasonable price also, but without laptop these days your education may not be fulfilled the way it should be. Lot of information, lot of requirement for various regions you must have. Although soon we will be providing you the computer facility in a month or so, maybe in the by next semester. We are buying computers and all, but your own computer can never replace the requirement. Okay. The legal issue was that habeas corpus. Habeas means where it is. A corpus means body. So where is my body? So whenever a person is missing, then you can directly approach the court, Supreme Court or High Court, to bring the body in front of the authority. Right? So habeas corpus writ was there, a girl was missing and police was not registering the case. This was the legal issue. So this legal issue was whether registration of FIR was mandatory under section 154. Now your answer should be quick. 154. Because the word shall is written. Many times when we write our normal English, sometimes we write shall, sometimes we write may, but in legal language, shall and may have different, executory value. Shall is mandatory. May is optional. Right? Although may also has more close to shall in common parlance comparing to, but shall is very, very assertive in nature. So this was the question. Judgment, when Supreme Court decide, it says it is partly not mandatory. Or you can say it depends on situation. If there is doubt that cognizable offense is made out, now question comes, what is cognizable and what is non-cognizable? Remember this also. There are two words, cognizable, non-cognizable, and another valuable and non-valuable. Understand it well, without any doubt. Cognizable means the offense where police need not to have warrant for arrest. You can directly arrest a person. Those are called cognizable offense. Sometimes you call cog offense. Cog. Many times you may have heard this word. Cog offense. There is another term is non-cog, non-cognizable. Means if you want to arrest, the prior permission or warrant by the competent court is essential. It is mandatory. And one thing, remember now, 154 section is for registration of cognizable offense. 155 section is for registration of non-cognizable offense. 155. Got the point? Clear? 154 cognizable registration, 155 non-cognizable. Very good. Police may take 15 days. Earlier it was 7 days when the original order came. It was 7 days for inquiring certain cases where there is a doubt whether cognizable offense is made out or not. Because there are allegations which have prima facie doubt. There may be some concocted story just to implicate somebody. And we will talk that why this problem is there. So police may take 15 days now. Earlier it was 7 days for inquiry into certain cases. These are the only cases where this Lalita Kumari case is applicable. In general, people believe that in all cases Lalita Kumari is equally applicable. Answer is no. There are certain category of cases where Lalita Kumari, meaning thereby the inquiry prior to registration of case is allowed. So these are the cases matrimonial disputes. Because many times matrimonial disputes, one person, one side, especially the female side, they generally want to implicate not only husband but many relatives just to put pressure. So in such cases, court find appropriate that there may be a kind of preliminary inquiry to find out whether cognizable offense is made out or not. Likewise, corruption cases. Somebody may implicate an honest officer. If it be mandatory, then the officer may have so many cases against him. So these cases are basically to protect the interest of the good persons. Likewise, medical negligence. Suppose if there is something wrong, something went wrong with the patient. Many, attendants or the family members, they want to implicate the doctor. There may be some mischief also, but not every time. But just to protect the interest of a sensible doctor. Then case reported after prolonged or unexplained or unreasonable delay. Suppose some allegation is that I was beaten 6 months back. Or likewise many sexual offense cases and many more so much. Right? So here you have long rope. Here many cases may come where there is an extraordinary delay. Here variety of cases may be taken up, but otherwise the rest 4 categories are crystal clear in Lalita Kumari case. Understand this. If inquiry reveal no cognizable offense, then the complainant has to be informed that we have not registered the case because cognizable offense could not be made out. So it is kind of informing, like 154(2) was giving a copy of the case, registered case. Here you are simply following the same method by informing that you have given this complaint, we have conducted inquiry, but cognizable offense could not be made out. That is why we are not taking any action or not registering the case. Supreme Court also directed police to record in general diary all complaints. Like many times you go to police station, they either ask you go out or they do not bother even if they take a complaint, and they simply ask you to go and they throw it to dustbin. This must be a situation sometime. So to curb those tendencies, Supreme Court in this judgment has categorically mentioned to record all complaints, whether you register or not register, whether you go for inquiry or whatever you do, but all complaints should be mentioned in general diary. So there are 2 terms to remember now in police station. One is CD, another is GD. This is another commonly used parlance in police fraternity. GD and CD. So GD is a general diary. General diary basically run 24/7 non-stop in any police station. Right from the day a police station came to existence, GD can never stop. It's a unending, everlasting process. GD, general diary, where every moment it has different fields to write at different time. Like in the morning time at about 6 to 7 o'clock, you have to go for Malkhana inspection. Then your roll call is there in the evening and morning, and so many other activities. Somebody is going out for any search or any police work or any holiday or any type of activity. Every description of happening at police station keep mention in this GD. And GD is a permanent document. It will be kept on police station. Although in some states there are some time, 5 year, 10 year and so, but if it is related to any case, then it will be linked with that case and then you cannot destroy it. So GD is a very, very sacrosanct document. Now many a times police, because it is a very cumbersome work, police do not mention many things, and this document is considered sacrosanct document. Whatever your GD says, you have to avoid with it. You cannot say I missed it or I did this way or that way. No, whatever is written, it is the final statement. So many times police get trapped in their own fait accompli because of the mismatch of their version and their case diary. The general diary. So this is another way of confrontation to the police and getting them into thick soup. The CD is basically case diary. Case diary related to the description of investigation. Description of what you have done for this case today when you are investigating that case. So it is description of a particular criminal case. That is case diary. It is generally in many places, in many states, it is in two leaflet, triplicate, or somewhere it is in duplicate. One copy remain in the original, jild, right? Another goes to police office, and third goes to court. In some places, if it is only duplicate, then one in the original and second goes to court through officers. So this is general practice being observed, right? Any question for this Lalita Query or FIR or up to this level? Anything? Commercial offense where finance is involved directly, maybe bank related case, or there may be some contract related issues and challenges where although contract per se is a civil matter, but if there is any fraudulent activity get involved, then it becomes criminal also. So financial cases, economic offenses, there are so many terms used. And you have asked one question, I will come to your question. I will understand one another term, very common term, is blue crime and white crime. Blue collar crime and white collar crime. Understand that. You know how these jeans were being brought in? Jeans that we use generally. Many of our friends have used, very popularly being used. I also like using it. Many of us. It was used basically for, okay, I don't say the term labor to avoid. That was basically used initially by the car repairing workshops. Those who were car mechanics, because their work was very rough and tough. Sorry. Mining were also being used, yes, no doubt. Meaning thereby that the work was very rough and tough, so that you need not to wash every time and all, right? Likewise, the rough and tough work or crime is called blue collar crime. Like road robbery and dacoity and this, where your life is in danger. Life of criminal is also dangerous, because many times if you are being caught by police or by even public, they are badly beaten and even sometimes succumb to the injuries. Okay, so the life is tough there. Compared to that, white collar crime is like people sitting in all AC room in a very good situation, and most of the time now, since last 25 years or so, what I have observed in my own career, that there is a significant migration or shift from blue collar crime to white collar crime. And the reason is very simple, because most of the work is basically now contract based, and contracts are being conducted or carried out by private companies or private identities. So there making money becomes very easy, comparing going to any road or going to loot any bank or any human being or any organization. That is more and more challenging. That is why you have heard now, when I entered into service in 1996-97, those days road robberies, road hold-ups, dacoities, they were very, very frequent and common. But nowadays their number has sizably reduced, because the money making in white collar crime is multifold than those blue collar crime, right? So this is the another difference you must understand. Now let's talk about online registration of FIR. Ideally speaking, everybody says that every crime should be registered. But if it comes to us individually, and if I say that yes, I don't care if any case get registered against me. Suppose if I have some enmity with somebody, or jealousy in business, or maybe individual base, people may implicate another persons. We have this tendency very well recognized, not anything hidden. So if we open to register case online every type of crime, do you agree that it is a good system for the society like we have in our country? Everybody agree to it? It should be, or yes or no? No. The reason for no is also supported by one fact, that in our country, if you get a case registered, even if completely closed or finally culminated or nowhere, completely closed or maybe trial you get acquitted, you have to carry that impression all through in your life. If you go for applying a job, there you have to disclose, yes, this case was registered against me and it was ultimately concluded with, or it was closed. But you have to mention. Many times there are innocent people who were not knowing or ignorantly they could not mention it and they got job, but because of that ignorance of not mentioning it, they were finally not selected. So the implication of getting case registered in Indian setup is very, very severe. In my opinion, this restriction should be uplift. That if the case is finally culminated into no punishment, right? Those cases should not be carried forward unwantedly. Until unless we have this kind, because you see, suppose you are the employer and there are two persons, one having case, whether it is culminated or not into punishment, and another is clean slate. To whom you will select? As simple as that. So what is the fault of that innocent guy who get victimized because of nonsensical person as a complaint? So in my opinion, I think we have to be little selective. We should strict our system for registration of cases, but online needs to be reconsideration if we go for every case to register. That is why on 19th September 2023, 22nd Law Commission of India in its report has recommended phased manner EFIR. It is very recent, hardly a month back. Today is I think 29th, 28th, just a month back. So very recently, Law Commission has recommended. In all cognizance offence where accused is unknown, of course there is no problem if unknown case. But if it is known, then punishment up to 3 years. They are petty offence, you can say. Frivolous FIR, false allegation, wrongful conviction. As I already mentioned, these are the issues and challenges if we go for registration of all cases online. This case is another important case. I request you all to read this judgment. Arnesh Kumar versus State of Bihar. Basically, this case is very important, and if it is observed with right soul and spirit, various problems of overburden of jail will reduce. What it says? It says that arrest of the accused in those cases where punishment is either 7 years or more only must be arrested. Otherwise, the below persons where the case has punishment quantum below 7 years, they should not be arrested until unless there is a reason actually for arrest. What are the reason? There is a chances to him to go abroad, he may abscond and can repeat the offence, and there are 4, 5, 6 type of exceptions. So if we follow Arnesh Kumar in right spirit, then lot of problem will subside. But neither the complaint has any patience. If you register a case, you immediately want that the accused should be arrested, even if it is just slapping case, very small petty things. So this is our psyche, just to punish the person through sending jail. So this mentality is need to be addressed, but this judgment you must read thoroughly, then you will understand more nuances of this. Crime versus offence I have already told you. other provision of law of investigation. I will tell you few things here for the purpose of understanding your CRPC. Now 154, registration of cognizable offence. 154(1), directly to police station. 2, you will get copy of it. 3, go to police, go to SP. If not, then 156(3), go to court. Your FIR up to this level over. Then 155, non-cog registration. What is non-cog? You cannot arrest a person without warrant. Now comes 156. So that back I have just recapitulated again. Power to investigate. So this section empower the police or any law enforcement agency for investigation. There are 157. I have not written everything. They are only important sections because unnecessary, otherwise you will miss to remember. When anybody call you to police station for inquiry, that is 160 notice. 160 notice may be in written form or maybe by a call. When you are being called by the police, technically speaking, it is, operation of section 160. Then statement before police is 161. कई बार आप सुनोगे 161 के स्टेटमेंट में इसने ये कहा, 164 के स्टेटमेंट में ये कहा. 161 क्या है, 164 क्या है, अंडरस्टैंड इट वेल. 161 स्टेटमेंट बिफोर पुलिस विच इज नॉट एडमिसिबल. ये भी आपको सेंटेंस याद रखना है, विच इज नॉट एडमिसिबल. क्यों नहीं एडमिसिबल? अगर ये एडमिसिबल कर दे तो क्या प्रॉब्लम होगी? पिटाई होना शुरू हो जाएगी, वायलेंस. यानी कि कन्फेशन जो है उसको डंडे के जोर पे पुलिस कराने लगेगी अगर हम पुलिस को एडमिसिबल स्टेटमेंट दे दें तो. लेकिन यूएस में नहीं है ऐसा. यूएस में क्या है, स्टेटमेंट बिफोर पुलिस इज एडमिसिबल. तो अगर कोई पूछे आपसे यूएस में और यहाँ क्या डिफरेंस है, ये बहुत ग्लेयरिंग डिफरेंस है. 161 क्या है, स्टेटमेंट बिफोर पुलिस. दूसरी चीज, कभी भी पुलिस जो है वो आपका स्टेटमेंट रिकॉर्ड करते हुए, क्राइम के मामले में कह रहा हूं मैं, ये जनरल इंक्वायरी है उसकी बात नहीं है, उसमें आपसे वो सिग्नेचर करने के लिए आपसे नहीं कह सकती. यू आर नॉट बाउंड टू साइन ऑन द स्टेटमेंट इन ए क्रिमिनल केस बिफोर पुलिस, वेदर यू आर एक्यूज और ए विटनेस व्हाटसोएवर यू आर. Any statement written by police, irrespective of your status being an accused, suspect or victim, witness, whatever you are, statement but before police, 1 is inadmissible. 2, you are not bound to accept it in the court. You can point blank refuse that I have not said it. Then 3rd, you are not bound to साइन ऑन दैट स्टेटमेंट. अब यह सवाल आता है कि क्या सारे सर्कमस्टेंसेज में पुलिस के सामने दिए हुए बयान इनएडमिसिबल है या कोई एक्सेप्शन है? एक एक्सेप्शन है, इसका याद रखना. ये सबसे ज्यादा सवाल पूछा जाता है. एक केवल एक्सेप्शन है, रिकवरी अंडर सेक्शन 27 ऑफ इंडियन एविडेंस एक्ट. इसको कहीं लिख लो आप. What is the exception of statement recorded by police for admission or on the ground of admissibility? What is the exception for statement before police? पुलिस के सामने दिए हुए बयान में उसकी एडमिसिबिलिटी का एक्सेप्शन क्या है? आंसर है रिकवरी अंडर सेक्शन 27 ऑफ इंडियन एविडेंस एक्ट. वो बात हम कर रहे हैं सीआरपीसी की, और यहां ये 27 क्या है, इंडियन एविडेंस एक्ट. इसमें कंफ्यूज मत करना, पता चला 27 सीआरपीसी लिख दो कभी. डोंट मेक डिफरेंस, प्लीज मेक डिफरेंस. ओके, सो 161 नॉन एडमिसिबल एक्सेप्शन रिकवरी ऑफ अंडर 27। अब यह कि रिकवरी किस चीज की, यहां सबसे ज्यादा कंफ्यूज करते हैं लोग, रिकवरी आर्टिकल की, नो, फैक्ट की वहां लिखना है रिकवरी ऑफ फैक्ट, अंडरलाइन करो इसको, रिकवरी ऑफ फैक्ट्स। फैक्ट में आपका आर्टिकल भी आता है, फैक्ट में आर्टिकल भी आएगा। अगर मान लिया उसने कैसे, इसका मतलब समझो क्या है, मतलब सिंपल, मान लिया आपसे उसने पूछा आपने हत्या की नहीं की, क्या किया आपने, जो भी कहा की नहीं की, कोई भी बात है। अब मान लिया उसको फायर आर्म से इंजरी हुई थी जिसकी वजह से हत्या हुई थी, ठीक है। पुलिस ने पूछा कि वो फायर आर्म आपने कहाँ रखा, फायर आर्म, तो उसने कहा कि मैं चल के दिखा सकता हूं कि मेरे घर में वो उस कोने में रखा हुआ है, ठीक? और पुलिस के साथ जा करके उसने वो रिकवर करा दिया, तो ये क्या हुआ, रिकवरी हो गई। ये पार्ट जो है 161 का ये एडमिसिबल माना जाएगा। अब दूसरी चीज को समझो, ये तो हुआ आर्टिकल। सपोज करिए ये एक लैपटॉप है, ये रिकवर हुआ किसी आदमी से और उससे पूछा गया कि भाई इसमें क्या क्या चीज है, इसमें क्राइम से रिलेटेड क्या क्या है, तो उसने बताया कि इसमें वीडियो बनी हुई है, इसमें मेरी प्लान है, इसमें मैंने कोई चीज खरीदी थी, कोई वो लिया था, वेपन लिया था, या कोई और सामान जिससे क्राइम करने में मुझे मदद मिली वो खरीदा था, उसका उसके बारे में रसीद है, या जो भी चीज़ है जो क्राइम को प्रूव करने में। अगर हम इससे उस फैक्ट को निकालते हैं, किससे, लैपटॉप से, तो ये भी क्या है, सेक्शन 27 की रिकवरी है, जिसे जनरली पुलिस नहीं करती है, जिसे जनरली पुलिस नहीं करती है। तो ये आपको अंडरलाइन करना है, कोई भी आपसे बताए पूछे 27 क्या है, तो उसे कहना कि ये फैक्ट की रिकवरी है, ना केवल वस्तु की रिकवरी। ये बात को ध्यान रखना है, है? नहीं नहीं, ये तो नॉर्मल बात है। फोरेंसिक तो पुलिस वो एक्यूज थोड़ी करेगा, वो फोरेंसिक का जो एविडेंस है वो कौन उठाएगा, वो उठाएगा फोरेंसिक एक्सपर्ट या पुलिस वाला। ये तो पुलिस की प्रेजेंस में, उस बंदे की प्रेजेंस में पुलिस कर रही है इस काम को उसके बताने के अनुसार, किसके अनुसार, एक्यूज के या सस्पेक्ट के, उसके जो बताया उसने, अगर आप उसको रिकवर करते हैं तो वो एडमिसिबल होगा अंडर 161। आगे चले, अब चलते हैं 164। 164 क्या है, स्टेटमेंट बिफोर मजिस्ट्रेट। तो अगर आपको यह है कि भाई मैं जो है मैंने कोई क्राइम कर दिया और मैं अब उससे मुक्त होना चाहता हूं, या मैं उसको बताना चाहता हूं, पुलिस के सामने बताओगे तो वो एडमिसिबल नहीं है। लेकिन अगर आप मजिस्ट्रेट के सामने बताओगे कन्फेशन को, तो वो क्या होगा, एडमिसिबल होगा, ठीक है। अब मान लिया किसी ने आपको डरा धमकाया, कि मैं पुलिस का ही नाम ले लेता हूं, मैं पुलिस वाला हूं इसलिए मैं कह देता हूं आपसे, मान लिया आपने पुलिस के डर से आपको ले गया और बाहर जो है दरोगा जी खड़े हैं और कोर्ट में अंदर भेज दिया और बताया कि अगर नहीं तुमने बताया ना तो फिर देखना भी आओगे तो हो बाहर ना, मजिस्ट्रेट साहब के पास थोड़ी रहोगे सारा टाइम, तो डर जाएगा वो। तो हो सकता है वो जो डर की वजह से अंडर ड्यूरेस, एक शब्द आता है ड्यूरेस, कंपल्सन, ठीक है, फियर, इंटिमिडेशन, ये सारे शब्द हैं कैसे आप किसी आदमी से जबरदस्ती कराते हो। दीज आर ऑल वर्ड्स यू शुड रिमेंबर, इंटिमिडेशन, ड्यूरेस, फियर, इन्फ्लुएंस, ठीक है, मिसरिप्रेजेंटेशन, ये सारी चीजें हैं। कई बार जो है आपको ये कह देते हैं कि भाई तुम क्राइम को एक्सेप्ट कर लो, तुम्हें हम और मदद कर देंगे, तुम्हारा क्राइम, तुम्हारा पनिशमेंट कम हो जाएगा, तुम्हारे और फैमिली वाले को किसी को हम जेल में नहीं भेजेंगे। देयर आर सो मेनी टाइप ऑफ एल्योरमेंट्स, ठीक है। लेकिन अगर आप कोर्ट में जाके बोलते हो तो कोर्ट इसको दूर कैसे करता है, इस अफेक्ट को कैसे हटाएगा, वो उसको टाइम देता है। अगर आज हम ले गए पुलिस वाले उसका 164 का स्टेटमेंट कराने, तो तुरंत कोर्ट उसको रिकॉर्ड नहीं करेगा, वो उससे पूछेगा कि क्या बात है, और उसे कहेगा कि आप 2 दिन बाद आइए, पुलिस को कहेगा 2 दिन बाद लाइए इसको, और तब वो रिकॉर्ड करेगा, ताकि उसके ऊपर अगर कोई एक्सटर्नल इन्फ्लुएंस है दैट कैन बी नलिफाइड, दैट कैन बी रिड्यूस्ड। एक और है यहाँ, इसको याद रखिए, मिरांडा वार्निंग्स, इसे नोट करो, इसमें शायद लिखा नहीं है मैंने, ये मिरांडा वार्निंग्स। मिरांडा वार्निंग 1966 में जजमेंट आया यूएस में, अमेरिका का है ये। उसमें क्या करते हैं वो, कोर्ट ये कहता है, कोर्ट ने ये कहा कि पुलिस वाला जब कन्फेशन रिकॉर्ड करेगा, पहली बात मिरांडा वार्निंग लिखो, मिरांडा वार्निंग 1966 यूएस सुप्रीम कोर्ट, यूएस सुप्रीम कोर्ट, क्लियर। अब उसमें वो ये बोलता है, जज उनको वार्निंग देता है कि नंबर 1, कन्फेशन करना आपको कोई कंपल्सन नहीं है, नंबर 1। नंबर 2, अगर आप कन्फेशन कर रहे हो तो ये आपकी स्वेच्छा से माना जाएगा, ये नहीं माना जाएगा कि आप पे कोई प्रेशर है। अगर प्रेशर है तो आप बता दीजिए, मतलब कहना ये है, आप ये कह दीजिए कि भाई मुझे जो कन्फेशन करने के लिए मुझे किसी का दबाव था, लेकिन मुझे कन्फेस नहीं करना है, या मैंने कोई ये क्राइम नहीं किया है। तीसरा, अगर आप कन्फेशन करते हो तो ये कन्फेशन आपके अगेंस्ट जो है एविडेंस के रूप में प्रयोग में आएगा। तो ये जो मिरांडा वार्निंग है, यही काम हमारे भी जो मजिस्ट्रेट हैं सेम यही काम वो भी करते हैं। और आपको ताज्जुब होगा कि जिस मिरांडा वार्निंग को अमेरिका के लोग बहुत बड़ी उपलब्धि मानते हैं, ये सेम वार्निंग्स हमारी जो 1898 की जो सीआरपीसी है उसमें सेम लिखे हुए हैं। इमेजिन दिस। अब मैं रिपीट करता हूं, जो मिरांडा वार्निंग्स हैं जो अमेरिकन कोर्ट, सुप्रीम कोर्ट ने, फेडरल कोर्ट ने 1966 में दी, वो हमारी जो 1898 की सीआरपीसी का जो वर्जन था उसके में ऑलरेडी ये सारी चीजें इसी तरीके से दी हुई हैं। और उसमें एक और अच्छा स्टेप है कि वहां तो पुलिस बोलती है उनको, हमारे यहां मजिस्ट्रेट के सामने, जो मजिस्ट्रेट इज कंसिडर न्यूट्रल। गॉट दिस पॉइंट? इज इट क्लियर? अब एक चीज और समझिए आप, मैं पहले इसको पूरा करता हूं उसके बाद बताते हैं। 164 आपको समझ में आ गया? 161 164 का अंतर क्लियर? अब आप आइए 165। मान लिया कोई हमें सर्च करनी है कहीं किसी के घर की, तो सर्च वारंट हम किस में लेंगे? 165 में। सर्च करने के लिए जो भी प्रक्रिया की जानी है वो किस में है? 165 में। तो अभी रिपीट करते हैं। 154 क्लियर, 155 नॉन कॉग, 160 उसको बुलाना थाने पे, उससे पहले 156 से इन्वेस्टिगेशन शुरू हो गया, 154 हो गया कॉग, 155 नॉन कॉग, उसके बाद आएगा इन्वेस्टिगेशन 156, उसे फिर थाने पे बुलाओगे 160, फिर उसका बयान लोगे 161, अगर उसने वो किया, कन्फेशन किया, तो कोर्ट में ले जाओगे 164। यहां तक आप क्लियर? बिल्कुल सीक्वेंस में है ये, इसे कोई कंफ्यूजन नहीं, एक दो बार लिख के देख लोगे, यू विल रिकलेक्ट। अब आते हैं 165 पे। सर्च करनी है उसके घर की, चूंकि कोई चीज का हमें एविडेंस लाना है, तो वी हैव टू डू इट बाय टेकिंग सर्च वारंट बाय द मैजिस्ट्रेट। नहीं तो आप किसी के भी घर में कूद जाओगे ऐसे, अगर आपको यह चीज का कंट्रोल ना करे तो। फिर यह है 166A। आप एक बात और समझिए, पुलिस ऑफिसर, बट आई एम ए पुलिस ऑफिसर ओनली इन माई कंट्री। इफ यू जस्ट स्टेप आउट ऑफ योर country, I am not a police officer, right? I have no jurisdiction to conduct investigation in other country except the embassy. एम्बेसी का जो प्रीमाइस माना जाता है वो टेक्निकली ये माना जाता है कि ये उस कंट्री की लैंड है। तो अगर कभी ऐसा कोई सिचुएशन होती है, हालांकि नॉर्मली इस पावर को कोई यूज नहीं करता है, मैं सीबीआई में रहा हूं, वो हम उसी कंट्री के पुलिस ऑफिसर से ही जो भी इंफॉर्मेशन मांगते हैं वही बयान रिकॉर्ड करके भेजते हैं। जो काम हम अपना यहाँ 161 में करते हैं वही काम वहाँ का पुलिस ऑफिसर, लोकल पुलिस ऑफिसर करके देगा, एंड इट विल बी कंसिडर्ड एज इफ इट इज डन बाय आवर पुलिस ऑफिसर। ओके, तो अगर हम अपने यहाँ से किसी फैक्ट को जानकारी करना चाहते हैं दूसरे कंट्री में, तो उसके लिए कौन सी धारा है? 166A, इन्वेस्टिगेशन ऑन फॉरेन लैंड, या इन्वेस्टिगेशन अब्रॉड के नाम से भी इसको जानते हैं, इन्वेस्टिगेशन अब्रॉड। क्लियर? और अगर हमसे कोई दूसरा कंट्री कराना चाहे वही काम, कि हमारे यहाँ कोई इंफॉर्मेशन है, कोई आदमी है, उसकी जानकारी करनी है, उसका बयान लेना है, कोई रिकवरी करनी है, वही काम जो हम बाहर से करा रहे हैं अगर हमें करके देना है दूसरे कंट्री को, तो वो 166। इज इट क्लियर? व्हाट इज 166 है? इन्वेस्टिगेशन ऑन आवर बिहाफ इन अदर कंट्री। 166 बी इन्वेस्टिगेशन बाय आवर कंट्री ऑन अदर्स बिहाफ। फिर अब 167, जब हम किसी आदमी को अरेस्ट करते हैं तो वी प्रोड्यूस हिम बिफोर द कोर्ट विद इन 24 आवर, विद इन, अदरवाइज तो उसको ला के फिर रखे ही रखोगे आप, उसे तो आप 2 दिन 4 दिन 5 दिन। तो अवैध कस्टडी किसको कहते हैं? व्हेन यू एक्सीड 24 आवर, राइट? अवैध तरीके से, अवैध कस्टडी, इलीगल कस्टडी। लेकिन अभी मैं उस पर आता हूं। हाँ, कोई भी है, वर्किंग आवर भी है या छुट्टी भी है, कोई बात नहीं है। जो इसलिए एक मजिस्ट्रेट बैठते हैं उसको कहते हैं रिमांड मजिस्ट्रेट। कोर्ट में वट एवर इट इज, दिवाली, होली, एनी फेस्टिवल, एनी हॉलीडे, एवरी डे यू हैव वन कोर्ट सिटिंग इन द ट्रायल कोर्ट, ऑलवेज, इररेस्पेक्टिव ऑफ एनी इवेंचुअलिटी। ठीक है? तो आपका 24 आवर में, लेकिन इसका एक एक्सेप्शन है, जो जहां से उसको पकड़ा गया है और जब तक थाने में लाने की जो डिस्टेंस है उसको उससे एक्सक्लूड करेंगे, लेकिन वो बहुत लंबा नहीं होना चाहिए। ये नहीं है कि आपका 2 दिन की जर्नी है, तो उसके लिए भी तरीका है, हंसने की बात नहीं है, उसका देयर इज ग्राउंड। उसको कहते हैं ट्रांजिट रिमांड। मान लिया हमने कोलकाता में किसी आदमी को पकड़ लिया, लाना है उसको कहां? लखनऊ लाना है। अब हो सकता है आपके पास अगर परमिशन है तो आप उसे बाई एयर ले आओ, लेकिन अगर आपको ट्रेन से लाना है या गाड़ी से लाना है तो आपको उसमें 2 दिन लगेगा, या पता नहीं कितना समय लगे, कितना डिस्टेंस है। तो फिर वहां का जो लोकल कोर्ट होगा वहां से आप उसको ट्रांजिट रिमांड पे लेकर आओगे। उतने दिन का समय वो देगा कोर्ट, एक लगभग लमसम टाइम निकाल के, कि भाई आपको 2 दिन 3 दिन जितना समय ट्रांजिट में लगेगा, दैट इज कॉल्ड ट्रांजिट रिमांड। दैट इज ऑल्सो पार्ट ऑफ 167। तो जब हमने उसको कोर्ट में दाखिल कर दिया, लेकिन 24 घंटे में हमने उससे पूछताछ पूरी नहीं कर पाए, तो उसको पूछताछ के लिए कोर्ट लॉ में फिर प्रोविजन है 167 में कि हम उसे पुलिस कस्टडी रिमांड पे ले सकते हैं, फॉर द पर्पज ऑफ कंप्लीटिंग इन्वेस्टिगेशन, फॉर द पर्पज ऑफ इंटेरोगेशन, दैट इज कॉल्ड कस्टोडियल इंट्रोगेशन। पुलिस कस्टडी रिमांड पे जो है 167। फिर जब हमने इन्वेस्टिगेशन कंक्लूड कर लिया, उसे हम सबमिट करेंगे रिपोर्ट, दैट इज 173, कंक्लूजन ऑफ योर इन्वेस्टिगेशन। इसे नॉर्मल जो हमारा लीगल टर्म है उसे कहते हैं फाइनल रिपोर्ट। वैसे हमारे यहाँ पुलिस में, यूपी में एक नया भाषा जो है, इसे फाइनल रिपोर्ट बोलते हैं, जिसे क्लोज कर देते हैं। पता नहीं कैसे ये आ गया, ये गलत टर्म है। वैसे फाइनल रिपोर्ट जो है वो 173 में है। उसमें क्या हो सकता है? या तो चार्जशीट लग सकती है और या क्लोजर हो सकता है। तो जिसे हम फाइनल रिपोर्ट कहते हैं लीगल टर्म में, उसका टर्म है क्लोजर रिपोर्ट। क्लोजर मीन्स यू कुड नॉट फाइंड एविडेंस सफिशिएंट टू बुक ए पर्सन, इसलिए केस क्लोज कर दिया, क्लोजर रिपोर्ट। ठीक है? ये हो गया 173। एक सेक्शन और है बस, अब मुझे लगता है तुम लोगों को नींद आनी शुरू हो रही है, वो है 173(8). 173(8) इसमें नहीं लिखा, अच्छा छूट गया वो, नहीं यहां लिखा है, हाँ आगे है, हाँ 173(8). अब ये समझो बात, जो हमारा लॉ है सीआरपीसी, उसमें कहीं री इन्वेस्टिगेशन वर्ड नहीं है, इट इज ओनली फर्दर इन्वेस्टिगेशन। बात समझे? फर्दर का मतलब और री इन्वेस्टिगेशन का मतलब समझोगे क्या? री इन्वेस्टिगेशन एब इनिशियो, यस, इसके लिए एक टर्म आती है एब इनिशियो। ये थोड़े से टर्म आप बीच बीच में कुछ कुछ याद करते चलोगे। जैसे एक कहीं लिखो इसको, एब इनिशियो, ए बी फिर गैप, इनिशियो INITIO, एब इनिशियो। इसे लिख लो फ्रॉम द बिगिनिंग, प्रारंभ से, A B डैश डैश में समझ मतलब गैप, गैप, इनिशियो, INITO, INI, इनिशियो, एब इनिशियो, राइट फ्रॉम द बिगिनिंग। री इन्वेस्टिगेशन का मतलब हुआ राइट फ्रॉम द बिगिनिंग, लेकिन जो हमारा ओरिजिनल लॉ है उसमें ये प्रोविजन है ही नहीं है। आपको जहां से खत्म हुआ वहां से शुरू करना है, फर्दर इन्वेस्टिगेशन वर्ड है। लेकिन बहुत सारे जजमेंट आए जिसमें अब री इन्वेस्टिगेशन वर्ड भी शुरू हो गया, इसलिए अब ये जो डिफरेंस है 173(8) का फर्दर इन्वेस्टिगेशन या री इन्वेस्टिगेशन, ये लगभग ब्लड हो गया। तो नाउ यू कैन स्टार्ट फ्रॉम द बिगिनिंग ऑल्सो, राइट। हालांकि जो हमारा जो मूल स्टैट्यूट है, जो हमारा मूल कानून है, उसमें कहीं भी अभी तक भी कोई अमेंडमेंट नहीं हुआ है और वो कहता है फर्दर इन्वेस्टिगेशन। लेकिन जो सुप्रीम कोर्ट, हाई कोर्ट के जो जजमेंट होते हैं उसका भी जो इम्पैक्ट है वो भी लॉ के बराबर ही होता है। तो ये आपको समझ में आ गया? इज इट क्लियर या कोई और कुछ क्लैरिटी चाहिए? कोई और किसी का क्वेश्चन? हाँ बोलो। हियरिंग इज पार्ट of trial only. Trial is a bigger thing. Entire proceeding, what is happening is trial. Proceeding, you are talking about proceeding. Hearing like say for example, you are giving hearing for a witness or something, that is a part of trial. Hearing चल रही है मतलब कोई है वो उसी का part. It is part of trial only, right? Any other one? Sorry? कंप्रोमाइज, यस। हाँ देखो एक चीज समझो, अभी ये अच्छा सवाल हुआ जो मैं छूट गया था, उसको मैं दोबारा से जरा पकड़ता हूं आपको। जब हम सोशल कॉन्ट्रैक्ट थ्योरी पाओ, रिमेंबर दैट व्हाट वाज द कॉन्ट्रैक्ट? कॉन्ट्रैक्ट वाज दैट वी सरेंडर सर्टेन राइट्स, पर्टिकुलरली राइट ऑफ इक्वलिटी एंड लिबर्टी। ये थोड़ा मैं उसको स्किप किया था कि वो टाइम लगाएगा, बट जब हमने कॉन्ट्रैक्ट किया तो हमने कहा कि हम लिबर्टी और इक्वलिटी की बहुत डिमांड नहीं करेंगे, लेकिन आप हमारी जान माल की सुरक्षा करो, ठीक है। तो इस ग्राउंड के ऊपर स्टेट ने ठेकेदारी ले ली। अब कोई भी अगर क्राइम होगा तो वो किसके अगेंस्ट माना जाता है? स्टेट के अगेंस्ट। इसलिए टेक्निकली स्पीकिंग एनी क्राइम इज कमिटेड अगेंस्ट ए स्टेट, राइट। इसलिए जब भी आप कभी देखोगे जो क्राइम होगा उसमें स्टेट ऑफ उत्तर प्रदेश वर्सेज ललिता कुमारी। और एक चीज और याद रखिए, जो भी पहला वर्ड होगा, जैसे मान लिया अगर स्टेट ऑफ उत्तर प्रदेश पहले है वर्सेस से, इसका मतलब वो कोर्ट में गया है, यानी कि पिटिशनर वो है। फर्स्ट पार्टी जो है वो पिटिशनर होता है और सेकंड पार्टी जो है वो डिफेंडेंट। नहीं, एक्यूज जरूरी नहीं है, एक्यूज जरूरी नहीं है, वो डिफेंडेंट होगा उस केस का। अभी मान लिया, सपोज करिए, इसको ऐसे समझिए, मान लिया केस लिखा गया एक्स व्यक्ति के अगेंस्ट, तो लिखा किसने? स्टेट ने। तो वो केस क्या कहलाएगा? स्टेट वर्सेस एक्स, ठीक है। अब उसके अगेंस्ट उस ऑर्डर के लिए गया जो एक्यूज है, तो वो क्या होगा? जब वो पिटिशनर हुआ एक्स वर्सेस स्टेट। अब मान लिया चले गए आप अपील में, ठीक है, तो जो आदमी जो पहले जिसको बेनिफिट हुआ उसकी जब अपील होगी तो पिटिशनर कौन होगा? उसका अपोनेंट होगा। तो वो एक्यूज भी हो सकता है और वो स्टेट भी हो सकता है। लेकिन सिविल मैटर में हमेशा जो है वो दो पार्टी होंगी, उसमें स्टेट से कोई मतलब नहीं है। लेकिन सिविल मामलों में भी स्टेट हो सकता है खुद पार्टी हो। मान लिया कोई जमीन का मामला है तो सिविल मैटर में भी तो कोर्ट में जा सकता है, या कोई आदमी स्टेट के अगेंस्ट जा सकता है कि भाई ये जमीन तो हमारी है, स्टेट ने जबरदस्ती कब्जा कर रखा है। तो पार्टी स्टेट भी हो सकती है आइदर वे इन सिविल मैटर। लेकिन अब मैं आपके सवाल पे आता हूं, क्योंकि वो दो पार्टी के बीच की बात है तो वो आपस में समझौता कर ले, क्या दिक्कत है हमें? वी हैव नो प्रॉब्लम। क्योंकि अगर वो मान लिया किसी का सिविल राइट का हनन भी हुआ तो कोर्ट, गवर्नमेंट थोड़ी कहेगी या स्टेट थोड़ी कहेगा कि आप मुकदमा करिए, वो तो उसकी मर्जी की बात है। यानी कि सिविल मैटर को यू कैन नॉट कंपेल द पार्टी टू कम टू कोर्ट। व्हाट द पॉइंट? इसीलिए क्राइम में कंपल्सन है। क्राइम में अगर कोई भी आदमी रिपोर्ट, मान लिया कोई सपोज करिए सड़क पे बॉडी मिली, कोई क्लेम ही नहीं कर रहा है, तो कौन मुकदमा लिखवाएगा? क्योंकि उसमें क्राइम इन्वॉल्व है, स्टेट लिखवाएगा। और स्टेट को कौन रिप्रेजेंट करता है? पुलिस। सो पुलिस विल बी द कंप्लेनेंट। लेकिन अगर घर का 2 आदमी का झगड़ा है और वो दोनों जो है वो कोर्ट नहीं जाना चाहते, तो मत जाइए, नोबडी विल कंपेल। अब आपस में आपका झगड़ा था पहले, अब आपने उनमें समझौता कर लिया, तो कोर्ट को क्या दिक्कत है? कोर्ट कहेगा ठीक है कर लीजिए। हस्बैंड वाइफ के बीच में झगड़ा है, वो नहीं जाते कोर्ट, वो आपस में घर में लड़ते रहते हैं, तो आपको क्या फर्क पड़ रहा है? ठीक है, अब वो चली गई एक हस्बैंड या वाइफ कोई, अब उनमें आपस में समझौता हो गया, तो कोर्ट कहेगा ठीक है कर लीजिए। क्लियर? सिविल मैटर आर बिटवीन द पार्टीज, स्टेट हैज नो बिजनेस, दैट इज वाई दे आर परमिटेड टू गो फॉर कंप्रोमाइज और कंपेंसेशन। मान लिया एक ने कहा कि भाई मेरा इतने का नुकसान हुआ था, इसलिए मैंने इस पर केस किया, अब इसने वो कंपेंसेशन दे दिया मुझे, आई वांट टू कंप्रोमाइज, तो कंपेंसेशन मिल गया मुझे, मैं आई एम हैप्पी। Why should I fight in the court? Go for that. Got it? All right. बोलो। Admissible? हाँ। No, it is not. Because ये तो बाकी के एविडेंस के आधार पे करेगा ना वो। It is not merely on the basis of the statement of an accused or any witness alone. वो तो जब सारे के सारे एविडेंस का जब आप ट्रायल में करोगे, when you evaluate whether this evidence or all evidence together is proving guilt beyond reasonable doubt or not, then only you go for ascertaining culpability. ठीक है, कि आप गिल्टी हैं या नहीं है। ठीक है, अब इन्वेस्टिगेशन क्या है, इसके बाद वी विल स्टॉप टुडे आफ्टर दिस स्लाइड बिकॉज वी विल टेक अप इन द नेक्स्ट स्लाइड सम टाइम। इन्वेस्टिगेशन, व्हाट इज इन्वेस्टिगेशन? इन्वेस्टिगेशन इज बेसिकली ए वॉयज। ठीक है, एक यात्रा है, किस बात की? एविडेंस कलेक्ट करने की, जिससे हम किसी की कल्पेबिलिटी को या गिल्ट को या उसकी इनोसेंस को सिद्ध कर सके। क्योंकि क्राइम में हमें 2 ही काम करने हैं, या तो किसी की गिल्टी सिद्ध करनी है और या इनोसेंस सिद्ध करना है। अब यहां सवाल आता है कि फेयर ट्रायल, एक ये बहुत बड़ा कंसेप्ट है। जनरली फेयर ट्रायल की बात करते हैं हम, लेकिन फेयर ट्रायल कब होता है? जब हमने फेयर इन्वेस्टिगेशन किया हो। अगर हमने इन्वेस्टिगेशन ही अच्छे से नहीं किया, हमने एविडेंस ही ठीक ढंग से नहीं किए, तो हम ट्रायल कितना ही भी कोशिश कर लें, कितना ही अच्छा जज ले आए, अगर एविडेंस ही प्रॉपर कलेक्शन नहीं है, तो हम कभी भी अच्छे ढंग से ट्रायल को फेयर नहीं कर सकते। तो ये कहना कि केवल फेयर ट्रायल से हम जस्टिस दे सकते हैं, ये अधूरा कंसेप्ट है। इसलिए हमें फेयर इन्वेस्टिगेशन को फोकस करना चाहिए। इसको हम दूसरे शब्दों में कह सकते हैं कि फेयर इन्वेस्टिगेशन इज द प्रीकर्सर टू फेयर ट्रायल। फेयर इन्वेस्टिगेशन इज precursor to fair trial. In absence of fair investigation or scientific investigation, you cannot ensure fair trial, right? इसमें करते क्या है हम? रिकंस्ट्रक्शन ऑफ पास्ट इवेंट। पहले क्या हुआ, एक एक एविडेंस हम चेन बनाते हैं, एंटायर चेन विद द डिफरेंट एविडेंस। कहीं हम उसका स्टेटमेंट लेंगे, कहीं हम उसका डीएनए करेंगे, कहीं हम उसका फिंगरप्रिंट करेंगे, कहीं हम सीसीटीवी फुटेज मिल रहा है उसको लेंगे। तो पूरे के पूरी चीज़ों को रिकंस्ट्रक्ट करने के बाद जब चेन पूरी हो जाएगी, उससे हमें ये पता चलेगा कि ये जो एक्यूज है ये आदमी कल्प्रिट है या नहीं है। तो ये कोरोबरेटिव एविडेंस उसमें होंगे, कुछ डायरेक्ट एविडेंस होंगे। तो एविडेंस कलेक्शन इज ए वेरी इंपॉर्टेंट पार्ट विच इज एन आर्ट एंड साइंस, राइट? कनेक्टिंग लिंक है क्या सारी चीजों को जोड़ने का? वो है डिफरेंट एविडेंस। तो एविडेंस इज अगेन जो हमने ट्रायंगल बनाया था, क्या? जस्टिस, ट्रूथ और एविडेंस। सो एविडेंस इज द कनेक्टिंग लिंक, बट कलेक्टिंग द करेक्ट एविडेंस रिमेन्स ए वेरी वेरी डॉन्टिंग चैलेंज। हमें इस सारे में करना क्या है? जब तक हमारे प्रोसीजर साफ सुथरे नहीं होंगे, फेयर नहीं होंगे, हैंकी पैंकी नहीं होगा, है ना, तो फेयरनेस इन प्रोसीजरल पार्ट ऑफ एविडेंस कलेक्शन रिमेन्स वेरी वेरी इंपॉर्टेंट पार्ट। अब आप एक चीज को समझिए, मैं पहले भी बता चुका था, इनकल्पेशन और एक्सकल्पेशन क्या होता है। कल्पेटरी वर्ड क्या है? कल्पेशन, दोष। तो इन मतलब जो दोष को इन करे, दैट मीन्स इट इज प्रूविंग गिल्टी। तो इनकल्पेटरी एविडेंस आर दोज एविडेंस which help to prove guilt. On the other hand, exculpatory evidence are those evidence which prove innocence. तो इन टर्म्स को frequently आपको यूज करना है, that these are inculpatory evidence and these are exculpatory evidence. Okay? And scientific temper basically, जो मैंने आपको पहले भी शायद बताया था कभी, कि जो किंग सोलोमन का था कि वहां दो महिलाएं एक बच्चे की मातृत्व को लेकर के झगड़ती हुई आई कि ये बच्चा मेरा है, दूसरी बोलती है मेरा है। राजा ने कहा कि एक तलवार लाओ, मैं बच्चे के दो हिस्से करके दोनों में बांट देता हूं। जब तलवार आई तो एक माँ चिल्लाई, एक लेडी चिल्लाई कि नहीं मत मारो बच्चे को, दूसरे को दे दो। और राजा ने क्या इन्फ्रेंस निकाला कि यही माँ है। तो वहां ना कोई डीएनए किया गया, ना कोई फिंगरप्रिंट, ना कोई आपकी फोरेंसिक साइंस। तो ये क्या है? साइंटिफिक टेम्पर है ये। तो इट इज नॉट ओनली मशीन, it is your scientific vision, how you think, how you correlate. So that is why investigation is both art and science. तो अगर कोई और आपका इसमें कोई सवाल है, कुछ है तो बताइए, नहीं तो अब इसको आगे कभी करेंगे, ठीक है? राइट? एनी क्वेश्चन? तो नेक्स्ट टाइम we will take up few another issues, that how we should collect proper evidence, and certain concepts also we will discuss about investigation, like beyond reasonable doubt, good faith, and many more things, other than when we will be talking sometime the general exceptions, like suppose there is a murder, right? Or in other word you can say there are situations, a dead body is lying on a road, it is a road accident, one person is killed, one person is dead. Another person situation, that one has a strong enmity and he has killed the person, that dead body is also there. Another one is that somebody enter into the home in the night, and to save a property and his body, the person killed the entrant, that body is also there, isn't it? Another person is like some accidental death is there, he fall down somewhere by mistake or something. So the end result is death of a person. But do you think that all will be treated same manner? No. Then what is the difference? Why we are treating differently? Because your intention of doing that thing is different. When you have the enmity, you have the intention to kill. But if you are driving on road, you are not expecting that somebody will come and hit by your car. You never expect that somebody will enter into my home and I will kill him. So all the situation actually depend on circumstances and how your brain react to it. So that is your mens rea, what she has mentioned. Mens rea is basically ill will, your ill intention. And then other part is your action, that is called actus reus. Right? Probably these all things have been taught in your class sometime, but we will just recapitulate in next, and then we will move for another areas which have been in your subject. So if there is no other question, yes please, yes, carry on. Ideally speaking, these things should not matter, ideally speaking, but we are all human beings. whatever we have gathered in our life, what kind of experience we had in our life, it actually reflects in our day-to-day work, whether it is a professional work, whether it is a personal relationship, whatever. So the personal, observation of a judge or any stakeholder in criminal justice system, they have their own mindset, they have their own lens of looking at. You cannot completely diverse. Ideally speaking, it should be as minimum as possible. The best way to minimize it, the best training, the best practices, the best reviewing method, so that a person, if he is committing mistake, it should be caught and it should be dealt properly. But you cannot completely wash out things, ideally speaking, that external affairs does not matter in decision making in judicial system. I am happy that you have read Just Mercy. Probably you must have learnt so many, and anyone or other than him has read that book? No? Yes, I think we have shared that book on this. Yes, हाँ, anyone? Movie देखिए, कोई बात नहीं, but read some books. Don't miss that. I hope you are starting getting your books now issued. Any problem in that? So soon we will be bringing more books. If anybody want any other book to buy of your choice, suppose, so you may give name to our sub-inspector there. Okay, any books, if somebody suggests that this book should be bought, we will be happy to buy. Enough money we have. And or any other thing which you want to improve the system. Next point is that I want your contribution in the development of the institute. One is close. So another point we can think of, like we are having our own website,